Mr. Maidman, good morning.
Good morning, Justice Marshall. If it pleases the Court, I want to begin by making one point that I think is very, very important in this case. In this case, in terms of the motion for new trial, the Commonwealth has never challenged that the defendant is seen in those annotated photographs at the very same time that Juan Nguyen is seen crumbling to the ground, and there is no muzzle flash in these photographs.
But didn't you present all that to the jury and argue all that before?
It was never presented that way.
But you had the same person testify, right?
It was never presented. I understand, Your Honor, but it was never the testimony that came out at the trial was not the same as was presented in the affidavit.
Yeah, but you
of the
can't go back and
investigator.
have another trial because you don't like the way somebody testified, and they could have testified a different way. Now that way lost.
Well, let me address that issue. I do not believe that trial counsel was ineffective. There's no evidence of that. I believe that the thrust of my argument is the 33E argument. I believe that the presentation that was done in the motion for new trial was significantly more cogent, was better, and that no rational jury would ever convict the defendant.
So is the first trial or the trial a dress rehearsal so that then the next time you can get it better and we just go on like that?
Well, the statute that this court reviews first-degree murder cases under for 40 years has looked at, was there an error? Did something happen in the trial such that justice was not done? And I would suggest to the court that this defendant is actually innocent of the crimes, and that the photographic evidence shows, not just beyond a reasonable doubt, but beyond all doubt, that he is innocent, and
But
that
then
he
if
did
it
not
shows,
shoot these two
okay, if
people.
it shows that so clearly, why didn't the jury see it the first time?
Because
Someone of the 12 people would have noticed it if it's beyond a reasonable
They
doubt.
could not have seen it, and I would suggest that the court might want to get the DVD and watch it and take a look at it and compare it with the annotated photographs. I have not seen the actual one that's in evidence. I have seen a similar one, which I assume is essentially the
You
same.
mean a copy?
It's a copy. It should be a copy. That's right. Of the actual DVD, the video photo. It's confusing what the video photo
Was
is.
that in evidence?
Yes,
Okay,
everything is in
so
evidence.
everybody saw it.
Everything in this case is in evidence.
We'll get it.
Well, we review it in any event.
Absolutely. And when you see that, what you'll see is a very high, and if you run it at the normal speed, the way it was done, as I understand, in the courtroom, it is very, very fast. It is not the frame-by-frame analysis that I put together in this motion for new trial.
But didn't the investigator testify at trial using frame-by-frame analysis? He could have.
Oh, certainly.
But
he could have. He
I
could have
thought
if he
the
had taken.
photographs, that there were photographs made of frames
That's right.
that
That's
went
right.
into
The
evidence.
photographs are in evidence. What I did, there's no mystery idea. It's in his affidavit. I went and scanned the photographs, and using Adobe Photoshop elements, I put labels on it based on what he told me. That frame-by-frame analysis, the photographs were put in, but there's very little testimony about those photographs. And I addressed that in my reply brief, because the jury never saw what I put in on the motion for new trial. And that's a critical point. If they had, they probably would not have been convicted.
Well, did the private investigator testify that, at least at trial, here is the defendant
Yes.
in this portion, and
Yes.
you're saying that that's still the same, only it's going much more slowly?
I did it. That's correct.
Okay.
That's a fair.
So isn't your theory, though, that the fatal shot was fired from someplace off the screen?
Yes.
And didn't the jury hear that same argument?
Yes. They did hear the same argument, but it was not presented in the same frame-by-frame analysis, pointing out here's what's in here is what the investigator says after watching 100 hours or whatever, and here's what it shows. The most important thing is that you will not see, you don't see it in the video footage, and you certainly don't see it in the photographs. There's no muzzle flash, and there was testimony about this at trial. And if there was muzzle flash, it was, take a look, you can see the lit cigarette, you can see the headlights. And one other point that I need to make, and it was suggested by the Commonwealth's brief, when I originally filed the motion for new trial in this court, I gave 2 copies of the actual photographs. Okay, you have them. Okay, they are better. For cost reasons, obviously, I couldn't make 17 copies of the actual photographs and put them in back of your briefs. You should look at those. I would also say you might want to take a look at the actual photographs, the unannotated exhibits. They might be slightly better. But just in preparing for today, I went back and looked at my copies of the photographs, and they're certainly better than what's included with the briefs. They're still blurry. I mean,
These are, I'm a little confused. These are your frame-by-frame photos?
Yes.
Oh, okay.
Yeah, and they were in
these
the
are the
original
ones
motion
you-
for new trial. Just that they cost a lot of money, and indigent
No, I
criminal
understand.
defense is.
Well, they're part, you made them part of the appellate record.
Oh yeah, absolutely.
Yeah. So you say,
And how many copies of that are there?
Well, the Commonwealth has one.
I mean,
these
it's
are
just-
these are my actual annotated exhibits.
We just have the one copy.
You
that-
actually have 2 copies. I gave an extra copy.
Okay.
so if we look at those, you say, and, you know, once we get a handle on what the evidence was and
Right.
all that stuff, we will come to the conclusion that he could not have done the shooting?
Absolutely. I believe
And
that.
you presented this to the trial judge, who looked
Absolutely.
at these
Yes.
and denied the motion.
Denied the motion without an evidentiary hearing. Didn't even get, didn't
But-
get a
but-
non-evidentiary hearing.
But you told him to do what you just told us to do. Did you not? You gave him this stuff.
Certainly was in front of them.
You made an argument like this, didn't you?
I wrote an extensive brief, yes.
Yes.
Extension motion.
So, being a conscientious judge, he must have looked at these. He didn't make any findings, you say,
Didn't make any findings.
no written memo.
There was a very short, one paragraph, which Commonwealth.
Did it address any of this
No.
frame-by-frame business?
No. No, essentially, he essentially said what this court has said. Everything was presented to the jury. The point is, everything was not presented to the jury the way I presented it. And I gave this, if you look at my reply brief, I addressed this. It was not reiterated and repeated.
Well, I'm sure the Commonwealth in a minute is going to get up and tell us, hopefully, why this frame-by-frame analysis is not dispositive.
Well, let me address that point. The Commonwealth never submitted its own memo. So it seems to me anyway, I would make the argument, they can't get up here and say, this picture shows this or this picture shows that, because that's not in the appellate record.
No, but you have said they've never challenged, your position is that if silence is assent, they have assented to your identification of who's who in those photos?
I would agree with that. I believe that's correct. I mean, they've never come out and said, that's not him, and that's not him getting killed in this picture, and there's no muzzle flash. And if the defendant was busy, tied up fighting with someone else when the guy is shot, and there's no muzzle flash, he couldn't have done it.
Might it not be a solution here if we get to the point where whatever you've given us creates a doubt, for us to remand this to the judge and say, hold an evidentiary hearing on this whole business and make specific findings and so forth?
I certainly would think that would be appropriate.
Before, you don't want us to go off and just say, well, verdict of acquittal. I know you'd like that.
I would like that. I'm not sure it's near. I checked 33. It doesn't. That's one of the options. Is not guilty, as I understand it.
Is.
No, it's not.
No.
Well, we
It
can
was,
do.
but I checked.
Isn't this or such other? I don't have it in front of me. Or such other. It should be in your brief. It may or may not be. Such other.
It should be. Yeah.
No, I don't think it is. I think you're right. I think it says may reduce
Yeah.
the verdict to a lesser degree of guilt or grant a new trial, period.
That's my understanding. But it's in
So,
there, but
the best you would get out of this at this point would be a remand for an evidentiary hearing.
that's correct, Your Honor. And if that happened, I would get the investigator up there. I'd make sure that one of the issues that came out, if you take a look at the transcript, there was a lot of, it really wasn't a cogent evidentiary presentation. It was every couple seconds, how do you know this guy is this guy? In other words, what's the evidentiary foundation that the person you say is in the person in the picture is that person? It was really broken up. I mean, again, I can't really fault Attorney Franco, the trial lawyer in this case. He did
There was a lot of
a reasonably good job.
There was a lot of confusion here, right? This
Abs-
was out in
this is
front
the-
of some kind of nightclub, and
Right.
everybody was milling around.
Right.
And there were a lot of Cambodians there and so forth.
Vietnamese.
It
Yeah.
was, late at night.
Did the at trial, did the
On my
prosecutor
standards.
challenge the investigator's designation of certain people on the photograph?
He tried. He nibbled around the edges at that. He said, for example, one of the things in the Commonwealth's brief, he said that he misidentified one person who had a full head of blonde hair, and he didn't. He tried to do it. Basically, it was more of a challenge, an evidentiary foundation challenge. How do you know this is the person you say it purports to be on the videotape? And the judge responded, the jury has seen this. Has seen this, and they'll take the evidence and evaluate it. But once again, I think that the critical point is that the jury did not see the presentation that I made, and that's I had, obviously, as an appellate counsel, I had the time to sit there and put this whole thing together, and this was in the middle of a trial, and there were other issues in the trial, and it never came out, and so the jury never saw
Was the
it.
identification of the defendant all circumstantial?
No.
No.
Oh no. Let me address that.
Weren't there witnesses who said he did the shooting?
Oh, absolutely. Well, there was one witness, the Commonwealth's cooperating witness, who was originally indicted for the same crimes after his fourth statement over 4 days said, yeah, that's him, and I saw him shoot both of them. And he also, he's in the pictures too, he says, I don't recall ever being in a fight. You can see the pictures. He's identified fighting and everything else. But he also, his description of how it happened is radically at odds with what's in the pictures. And that's also true of at least one other witness, Mr. Dung Koo, who basically says that the defendant walked up to Juan Nguyen and shot him. Well, if you can see Juan Nguyen literally, over the, it's really 5 seconds.
How did what is the basis of your investigators' certainty that who he says is Juan Nguyen or Nguyen
Well, they
is
know it's
indeed?
Juan Twin because he's where he fell down, and you could see in the picture. That's where they found him.
All right, well,
So
all
he-
right, let's
he's
take
easy.
somebody who's not a victim.
He's the easy one.
Okay. These witnesses, the other witnesses.
Yeah, the other, well, yes. His basis is having watched this thing for hours and hours, and also basically it's contextual, putting everything together, what people said, and there's also one statement that was not brought out at trial from a witness. It came out in the police discovery, saying that I was pushed to the ground by my friend, and those pictures.
Right.
Those actually in the photographs. And more than that, she says, I heard bang, bang, okay?
Yeah.
In other words, the two shots being fired very close. Most witnesses say close in time. I think only one witness says they're a second or two apart. Most people say it was...
But so the investigator, is basing his identification on witness testimony either at trial or in police reports?
Police discovery at trial. I'm not sure how much at trial, because he was...
He doesn't know
He was
any of
sequestered
these
from the
people,
room, so he
correct?
wasn't there. They kept him out. But based on all the police discovery, having seen spending hours watching this tape, more than that, he basically was contextual, just taking everybody's story and reading it, and you can see where the people, and he put all the pieces together, connected all the dots. And when you look at it, it's a pretty cogent presentation. It certainly raises doubt. And was there, sufficient evidence for required finding a not guilty at the close of the Commonwealth case? Of course, at least 2 people said he walked up and shot him. I argued in the brief, for the purposes of the brief, that there was deterioration, which arguably there was. But the real issue is when you take a look at this and you sit down and you go frame by frame, and also I included his affidavit in with the brief.
That's the investigator.
Yes.
Yes,
Actually,
you-
I put a copy in there. If you take that and you take the pictures and you have the actual pictures and you go frame by frame, read this thing, it raises doubt. I don't know how else to put it.
Okay.
I don't know how else to put it. I mean, it's certainly, if your responsibility is pursuant to 33 to take a look at the entire case, this is something you really have to very carefully examine. And with that, unless the court has any further questions, I'll sit down. I'll
Mr.
rely on my brief.
Maidman, thank you. Ms. Lynch?
Good morning. May it please the Court, Bethany Lynch, Assistant District Attorney for Hampden County, representing the Commonwealth.
Why don't we start with this major argument here? You've obviously evaluated it and gone through it because you knew it was coming. What do you say about it?
Well, I say that the defendant's argument hinges entirely on crediting the affidavit of his investigator. You can go through and you can match up what the investigator says the picture shows with the picture, but unless you credit his identifications, you can't. His affidavit does not help in any way.
Have you or anyone with familiarity with the Commonwealth's case and the facts filed an affidavit discrediting those identifications?
No.
So how are we going to be able to tell who's who in this whole thing?
That would be the Commonwealth's point. We would agree that the victim in the videotape is the victim, that he's properly identified.
Which victim?
There was one victim who was shot in the head. He's not shown anywhere on the videotape. There's a second victim who was shot in the side. His name is Han. The pronunciations are difficult, but he was shot in the side and fell next to a car. He's in the video, and there's no dispute that that is him. At trial, the Commonwealth also agreed that the defendant was properly identified in the videotape. We did not agree that the other people were properly identified. We challenged the investigator's identifications based on foundation, based on things like his basis for identifying one of the men was the color of his hair. We challenged, weren't there more than one person with that hair color? Yes, there was. So
If the Commonwealth was attempting to find out what happened, did the Commonwealth itself try to identify who was whom?
No. Well, we didn't take it and put it on DVD and do a frame-by-frame photo printing. We didn't have that until the middle of the trial.
Let's assume that you obviously didn't do that. Could you just address why we should uphold the motion for a new trial conclusion when there was no evidentiary hearing?
Well, I would argue that there was no need for an evidentiary hearing because the evidence was presented in the affidavit, and the judge did not credit that affidavit clearly. He had the affidavit which set out the defendant's entire defense, including the fact, according to his interpretation of the tape, that at the exact moment of the shooting of Han is captured on film, which we disputed at trial, and the motion judge, being the trial judge, knew that. If you accepted everything in the defense investigator's affidavit and you credited that, then there would have been a doubt. The trial judge, sitting also as the motion judge, who viewed all of the testimony, who saw all of the tapes, he saw all of the photographs, and he saw all of the witnesses testify, was the one who was determining whether or not a motion for new trial was justified in this case.
Shouldn't he have written something about it?
Well,
if the argument is as powerful as Mr. Maiden suggests it is, and he had the benefit of the frame-by-frame and the investigator's affidavit and all that kind of stuff.
Well, the only thing new in the motion for new trial were the annotations, which the Commonwealth would have objected to had they been offered at trial, because they were, in essence, an attempt to testify by saying, oh, at this point you can see there's no gun, where the photograph is so blurry that I would argue that it would be difficult to know that, or the identifications. By identifying certain individuals, that was, in essence, testifying. We would have objected to the annotations on the tape, on the photographs. The only thing new was the affidavit of the investigator, where he set it out in a frame-by-frame manner. All of the photographs were in evidence before the jury. The videotape itself, both the original VHS cassette and the DVD, was in front of the jury.
There's no claim here that there's any inconsistency between the DVD and the VHS.
No.
How much has the Commonwealth seen of these reproductions?
We've seen all of the reproductions, as far as I know. There's a great
So
deal
how
more of the
do you
tape.
respond on the merits to the defense counsel's claim that the defendant could not have fired the shot if what is shown on the DVD or whatever it is correct?
Well, the DVD, when you watch it, or as it's represented in the photograph, shows a very small portion of what was going on outside this nightclub. There was a separate murder that happened that you cannot see. The jury also went on a view and could see
I believe,
how close.
correct me if I'm wrong, it seems to me from remembering the argument in the brief that his client was on the ground when the fatal shot was fired, and that the photographs will show that.
No, his client it was the Commonwealth's position at trial that the shootings both occurred before this sort of group of people came into view, and that the victim who falls on the tape was shot off camera. There was testimony from a pathologist that the wound that he had it caused an internal bleeding that would have allowed him to remain standing for a period of time. The tape itself only shows between 3 and 4 seconds of time. And so that small portion was not enough.
Do you let her finish the small portion?
The small portion of what you saw was not, it wasn't definitive as to what happened on this scene. There was no showing of the other killing. The man was laying apparently directly underneath the camera. The jury did go on a view. They saw the position of the camera and they saw the distance.
Why is the video only 3 to 4 seconds? I mean, I take it.
Well, the video is much longer, but the part where you can see any activity at all relating to the shooting is only 3 to 4 seconds. The jury actually saw it for a very lengthy period of time leading up to the shooting, and really there was no activity. There were some people milling around on the sidewalk.
So your argument is essentially that you can't see everything that happened.
Right. You can see very little of what happened according to the testimony of the witnesses who were there. And it's really fairly, except for the identity of the shooter, it's not disputed what was going on the sidewalk before the shots were fired.
That second murder, was that happening simultaneously with this shooting?
There were 2 victims. This was a double homicide.
And the bullets came from the same.
They only recovered 1 bullet from the man who was shot in the side. The bullet lodged in his pelvic bone. There was the second man was shot in the head, and they did not recover the projectile.
There was some discussion about the absence of any muzzle fire from, or muzzle, the glow in the video. Was there any testimony one way or the other that indicates how much time the muzzle flame would appear if in a fast sequence of pictures, or how many seconds apart you would need in order to capture the muzzle fire?
There was no testimony to my recollection as to how long muzzle flash lasts. There was testimony as to how quickly you could fire a gun twice, and you could do that with nearly instantaneously. But there was no testimony as to how long a muzzle flash would show up on a videotape.
Okay, so you wouldn't necessarily have to have seen muzzle flash on any of these sequences.
Right, right.
Even
We don't know if
there
was any muzzle flash.
Was there testimony to that effect? That in these circumstances, even if there had been a shooting while this was being recorded, the video and enhanced DVD would not have picked up muzzle flash?
No.
So that's your opinion?
Yes. Well, I mean, there was testimony as to what muzzle flash is.
No, I understand that.
The only testimony offered was by a defense witness who testified that he watched the tape and didn't see any.
No, I understand that, but we don't know. So
we don't know that it wouldn't have shown up. We just know that.
And we don't know that it would have shown up.
Right. We don't know. All we know is that he knows what it should look like, and he didn't see any.
In regard to Justice Graney's question of possibly remanding this case with instructions to the trial judge to look at the, whatever it is, the pictures that the defense counsel wants the judge to look at, what would be the harm in that from the Commonwealth's point of view?
Well, the harm would be, I don't believe that it's necessary. I would argue that the judge
Okay, so it's not necessary in your opinion, but what would be the harm?
Well, I think he already did. He made a very brief findings, he issued an order where he says that the jury viewed the same video footage and photographs as are attached. I would argue that that implies that he did look at the thing.
But he doesn't make any findings
He
in
didn't make
regard to
anything
it.
specifically.
So if we remand it to him with instructions, either to look at it again, or if he's looked at it to refresh his memory, and then to make findings, what would be the problem? Defendant's locked up. He's not going anywhere.
Yeah. I guess there wouldn't be any real harm, except, again, I don't believe it's necessary, and I believe that he already looked at it, and being as he was the trial judge and the motion judge, he calls this just a mere recapitulation. He says that the jury chose not to credit the testimony of Mr. Tatro, because that was the investigator at trial. And at trial, he may not have testified as specifically as the affidavit. He did not go line by line and identify every shadow as he attempts to do here. But he did testify as to that's the defendant. And I was in court when this was happening. They did stop the tape. They didn't just play it very quickly, and that was the end of it. It was stopped, it was started, it was who's that, can you tell what that is, that's a bottle, that's this. All of that was before the jury.
So is there anything new here?
The only thing, it's not new as much as possibly more detailed.
What about the photographs?
The photographs were all in front of the jury. The only thing that's different about the photographs is the annotations, which are attributable to the investigator.
He could have made those annotations
Absolutely.
before. But
I mean, he could have tried, again, at trial we would have objected to the
If
annotations.
he's testifying,
but he
if
could
he's
have.
saying,
Oh,
you
he
know,
could have pointed, absolutely.
and then he could have marked a notation on it saying, with a sticker or post-it, and saying that's, I mean, so.
Yes, he could have done that
He
to
could or
reflect his
couldn't.
testimony.
I mean, you still might have objected.
We would have objected to annotated photographs such as these going before the jury. But these photographs, unannotated, did go to the jury. Every single one of them and more.
And at least in testimony identified.
Yes. In his testimony, the investigator identifies the defendant. He investigates the victim on screen. He identifies the co-defendant, Ting Dao. And he identifies a fourth person, the blonde-headed man whose name is An Huynh. He identifies all of them, and the Commonwealth objected repeatedly to all of these identifications based on a lack of foundation. He testified that he knew them from seeing them come in and out of court.
So you've gone through all of this very carefully, obviously. You've looked at the whatever was filed in connection with the motion for new trial from the investigator and the frame by frame and the whole business. You've compared it with the trial record, and it's your position and conclusion as an advocate for the Commonwealth that this adds nothing new, correct? Nor does it shed any doubt on the defendant's identity as the shooter.
That's correct.
Is that fair to say?
Yes.
And I take it that's for two reasons. First, at least two that you've said today. One, that the shooting occurred before this 3 to 4 second flaming, because the victim who during that period of time falls could have been standing after a shot had been fired.
Yes.
Correct? And the second is there's no evidence to suggest that may be sufficient. The second is there's no expert evidence that said if a shooting had occurred at the time that you would see a muzzle flash in these circumstances.
That's correct.
Was there testimony challenging I assume the pathologist or whoever else testified that with the kind of wound that I assume was identified with this victim, that victim could have stood?
There was that testimony, yes.
Challenging that.
Oh, challenging that?
Yes.
No, not that I recall. It was the defense attorney was attempting, obviously, to say that as soon as he was shot, he fell. That was the evidence he was trying to elicit. And the pathologist, actually, it was his own witness that he called. We had our medical examiner testify as to cause of death and things such as that. The defendant called his own pathologist to testify and attempted to have her utilize the tape in making her determination of when he was shot. And she said that she was not, without viewing the tape, she couldn't say what position he was in or anything, but that the kind of wound that he had, it caused a great deal of internal bleeding, and that internal bleeding would lead to a drop in blood pressure, and after a period of time, the victim would fall to the ground. She couldn't
Ms. Lynch,
say.
just remind me, where was he shot?
He was shot in the right side, and it went through his stomach, his intestines, but it didn't sever, perforated his interior vena cava, which is a major blood vessel that comes from the legs up, apparently. So that was perforated, so a hole was punched in it, and he began to bleed. And he bled internally for a period of time. And he passed away, I believe it was an hour and a half to 2 hours later, from the time of the shooting until the time of death. So it wasn't an instantaneous killing shot, if you could call it that. And the defendant's own pathologist testified on cross-examination that the victim could have stood for a period of time. All of these arguments were also presented to the jury. This was the theory upon which the Commonwealth presented its case. The defendant presented his case based on exactly what he's arguing here, that according to the investigator, the shooting happens on camera. According to the investigator, these people are all doing different things. And according to the investigator, if this is witness X, so-and-so, whichever one, it contradicts this. All of it had to do with believing the investigator's interpretation of that videotape.
Well, what he says on that point is, I believe that if the defendant had fired a handgun during the period of time captured by the video footage, the muzzle flash from the firearm would have been unmistakable, right? So that there's
Right.
nothing in that paragraph that is inconsistent with the Commonwealth's view.
Right. And again, both sides were presented to the jury, and the defendant urged in the strongest terms the jury to watch the videotape, to look at all the photographs. They arranged to have a DVD player. He said watch it repeatedly to get to know the people. So this information was all in front of the jury, and the jury made the determination to credit the live percipient witnesses who were at the scene of the crime, who identified the defendant as the shooter, rather than the testimony of the defense investigator, who was putting his own interpretation on the very small sliver of the action that you could see on the tape. And so because of that, there's really it would be the Commonwealth's position that there would be no need to reduce the verdict or to remand it back on the motion for new trial, because there would be nothing new to be gleaned that in terms of the new trial, the motion judge looked at the things and said it's the same thing we already saw. The jury already made the determination. And because the jury is the body that should be making such determinations in terms of identification and which interpretation of the evidence to credit, it would be basically stepping in and overturning their credibility determinations in order to reduce the verdict. If you have no further questions.
Mr. Lynch, thank you.
Thank you.